have here, Jim?
Judge, I want to be brief in my presentation, and then I'll take any questions, but there was a motion brought by the predecessor before I got involved in this case, seeking to set aside an order issued by the Judge Hogan back in July of 2011. The motion was brought pursuant to Rule 450-1, approximately 10 months after that order was issued, seeking to reopen the accounting and to obtain certain documentation. I think it's important to go over the procedural history at the time. I think as the court is aware, this matter involved an unsigned copy of a will being admitted to probate.
Now that the Supreme Court's, the appeal has been dismissed.
Yet we subsequently settled the case,
Right.
Judge. And
You
so
settled the case?
We did, we settled it.
So what's,
So now the issues are, Mr. McInerney, there's motion to have Jonathan appointed as executor under the will.
right,
And Mr. McInerney has given us an final informal accounting.
right.
And we're in that process. And I guess as part of this appeal is the idea that Jonathan wanted access to all the documents to determine, from beginning to end, what occurred. And,
Right.
and whether he questions the conduct or not, that's for another day. And I guess that's why we're here. We're here to determine whether we are bootstrapped by the res judicata effect of the first accounting. Now, procedurally, what happened at the time, April 20th of 2011, summary judgment was granted. Mr. McInerney filed his accounting on May 31st of that year. The hearing on the accounting was June 17th. It's approximately 17 days later. My understanding is that was some documentation forwarded, but not a lot. At that hearing, the understanding was that Jonathan Ehrlich would be appointed as executor, Mr. McInerney would step down, and they were treated as a final accounting.
Right.
No exceptions were filed,
Right.
and the thought was that Jonathan would receive all the documents. If there were any issues, he would deal with them.
Right.
The judge issued an order on July 15th, accepting the accounting is filed. 10 months go by. There were other proceedings. There's an appeal going on. There's a stay issued. And the accounting comes up in this motion for reconsideration, for lack of a better term. It was a 450-1 motion. My predecessor had said that he wasn't sure whether it was an interim accounting or not, or whether it was final or not. And the judge, even in her dicta, had even though she ruled against my client, had said that, well, there's going to be an update to the accounting, and at some point we're going to talk about all this. She said something to that effect. Now, so what I think Jonathan is concerned about, and what this appeal basically is about, is are we bootstrapped by the basically about the approval of the first accounting?
Let's take a look at this factually here. And there were disagreements. First of all, the first intermediate accounting, which was labeled final, it was all acknowledged at the time that there were assets in the estate not included, for whatever reason. Right. Now those assets, I understand, were three stock holdings in three companies.
Correct.
Yeah. But they have since been identified, haven't they?
They have.
And accounted for.
In the informal accounting, they have.
As well as the dividends.
Correct.
The informal accounting. Okay. So, and then there's a personal property that was personal property sold at an auction, and you wanted some photographs?
Correct.
What about that?
We have not received the photographs, but Mr. McInerney has been compliant. We've been receiving documents
I
over the
don't
last
see why this
few weeks.
can't go forward to a final accounting and get all this worked out at that point.
I think what my concern is why.
What is the res judicata effect? They've already acknowledged that what you had disputed originally is now included in the estate.
Well, there are issues. For instance, there are ongoing issues that were started during the first period that are continuing, like the sale of the house. It occurred in the second period, but should have been done earlier. I don't know. Compensation from beginning to end. Are we able to now go back and say, well, certain things shouldn't have been done during the first period? I'm concerned that Judge Souter may say, well, Mr. Clicchio, you can't talk about that because it was already approved. And that's really my only concern. And
yeah, I think there's enough though on, well, okay, I understand.
Right, so that's my concern, and I guess that's why we're here today, to talk about that. And I'm not talking about, there are two concerns basically. One is whether we're able to talk about those issues. The second thing is the disclosure of documents, which I believe Mr. McInerney is willing to give us. So I think that's less of a concern in my mind at this point. So those are really the two issues that continually concern me. Now, Jonathan, at this point, there was a beneficiary, the will has been admitted to probate, he has yet to be appointed, we have motions on. And there was a trust set up for a lady named Catherine Harris. She's been paid, there's a release been obtained. So at this point, and Jonathan's siblings have been paid. So essentially, at this point, Jonathan is the sole beneficiary, he's the executor. So at some point, presumably, he's going to receive all these documents as the executor, and he's going to be able to look at them. And I will, so I guess what I'm after is a remand or an order that basically gives us the ability to look into the issues from beginning until end. And, for Jonathan, at the point that this accounting was actually approved and the order accepting the accounting July 15, 2011, there were subsequent motions trying to remove Mr. McNair. He acted pro se. It was not until he then rehired Mr. Mellis that this issue came up. So I don't know if it's fair to bootstrap Jonathan with that res judicata effect. If there's any other questions, I'll answer them.
Thank you, judges. I'll rely on what I submitted, but I think I just want to put this in some perspective. What you're asked to do is to second-guess Judge Souter's order. Judge Souter's order basically said Judge Hogan's order from the year before remains in effect. And I filed the initial accounting. It was captioned as a final accounting. It turned out that Judge Hogan asked me to continue as administrator. It was originally thought that it would be my first and final accounting, but it was not. It was only after I had filed the first accounting and it had been approved that these other assets came to my knowledge. So, and they've been accounted for in the subsequent accounting, including any dividends that were received by me later. So when I filed the original accounting, it was accurate as far as I know up to that point. There were no exceptions filed to the accounting. There was no request for additional documents or anything like that. The judge approved the accounting, approved the fee request, and that was the end of the matter until 11 months later. What you're asked to do is decide whether or not Judge Souter abused her discretion when she refused to reopen Judge Hogan's order. And I think unless you can see where she abused her discretion, that order or that motion, the decision of the motion really has to stand, because I believe that's the appropriate level of appellate review at this point. Now, in the meantime, the estate has moved on, and hopefully we're wrapping up the estate.
It seems like the big issue has been resolved, and you have a will.
Well, we do, and I've provided Mr. Quickie with an informal accounting. I haven't got a response on any issues, but and I'm prepared to file a formal final accounting.
An unsigned will.
Well, that is a document intended to be a will, Judge. I guess is the way to refer to it.
I think I understand. We understand the position.
All right.
Thank you, counsel.